Hello, and welcome to the Arbitration Conversation. So in this conversation, we're going to really learn from an expert who has been in the trenches as a dispute resolution specialist for a long time, has decided or has resolved just about every type of dispute, has an amazing and interesting background, and is going to give us some thoughts on moving your practice online, which of course has been happening by leaps and bounds during the COVID-19 pandemic. So I'd like to welcome Karl Bayer. Karl, thank you so much for coming. I really appreciate your taking the time. I know you're super busy, so thank you.
Thank you, Amy. It's nice to be here. Thanks for having me.
Well, I would like to hear it from you. You have an amazing, very interesting background, and I would love for you to explain, how did you get into dispute resolution? Because you have an MIT background, you've worked with radars, you have a really interesting background. So please explain, how'd you get into dispute resolution?
Right. Well, I was first I was a trial lawyer for probably over 35 years. And during the course of that work, one time in probably about 1988, a district judge in Travis County, Texas called me and said, can you mediate something for me? I didn't even know what mediation was. And I had the typical trial lawyer bias against arbitration, but I thought, well, I can do a favor for a district judge. I will. And so I mediated that case and enjoyed it. And it gradually became more and more of my practice, both mediation, arbitration, and courtmaster work. I do about a third of each now, and it's a nice blend. But I don't do any trial work anymore.
Well, and now I guess once you sort of gotten into dispute resolution, sounds like you've kind of changed your litigating ways a little bit.
Well, I don't know. I still have great respect for excellent trial lawyers. And frankly, as a neutral, either hearing their arbitration case or a courtmaster hearing or whatever, it's a great day for me to have a very experienced, self-secure, well-trained lawyer that's client-oriented. That still really helps me out the most as a neutral. And so I do appreciate it. But yes, as you point out, unfortunately, through lots of different reasons and causes, there's a strain now of a trial lawyer out there that is actually sort of, in my opinion, destructive of the resolution, particularly in a business case, getting a business case resolved.
Right. Well, one of the kind of interesting aspects, of course, of COVID-19 has been the fact that all of these different processes, be it mediation and arbitration, are moving online, which really requires different skills. And you've had to move your practice from really all face-to-face to online. And I would love to get your sort of tips and tools and your top 3 that maybe you would provide to, first of all, arbitrators, and secondly, to those representing parties in an online arbitration.
Okay, well, great. When I first started doing this out of necessity, sort of back in March, I was kind of hat in hand. I was very apologetic. Oh, I'm so sorry, it won't be as good. I'm totally converted. So everybody needs to know that I'm a zealot now. But on the arbitration stuff, I think as a neutral and looking at it through the eyes of a neutral, I think some of my tips would be to arbitrators, really don't hesitate in asking the lawyers to, and expecting and almost demanding, not requiring, but that they develop the case from an online perspective. And there are some differences. They're mostly strengths, in my opinion. A few not so much. But so for somebody that's arbitrating with Zoom, and there are other platforms, of course, and I work on them as well. But with Zoom, it is so easy and so ubiquitous now that I think focusing on that platform as an arbitrator and using that is going to be the right way to go. For a lawyer, learning the platform that the arbitrator uses is probably the number one thing. You should, once you learn that whatever the platform is, Zoom, Teams, WebEx, whatever, really mastering that platform, or having somebody on your litigation team that knows how to do that, or even hire somebody that knows how to do it, because it just makes it all run more smoothly. And the reason I say that in particular and stress that for people, lawyers in arbitration, you would never think of letting the arbitrator get up from the desk and leave the room to go to some other place. The equivalent of that online, frankly, is not exactly knowing how to use the arbitrator's platform, referring them to some other document where they have to open another app. In other words, not making it easy to stay on the arbitrator's preferred platform. And I think I would always, as the arbitrator, even if there's some other technical person that's hosting the arbitration, I would insist that you can co-host the arbitration with them, because that will allow the arbitrator to set up breakout rooms, which of course is the sweet spot for Zoom. And you can set up essentially an office building experience. You can have a joint conference room. You can have breakout rooms for each of the legal teams to prepare their witnesses or listen and not be involved. And you can even have the equivalent of what I call lawyers bumping into each other in the hall. You can have a breakout room just for the lawyers to go and visit, the opposing lawyers to go and visit. So I could go on, but that's kind of the overarching thing I would say. And then secondly, for everybody, and they didn't teach us this in law school, it's all about this little small screen that you and I are looking at. It's all about that. We don't have the cues of an office conference room, really. We don't have the cues of a courtroom. We have to create the environment and recognize that we're in a very equal, everybody's the same size. You and I are both the same size. Yeah. No more hierarchies between arbitrators and litigants. And also realize that you're not only the director of the play that's unfolding in the arbitration, you're the producer too. You got all sorts of things like lighting and witness backdrop and all sorts of things that you didn't have to think about before. I find it kind of fun. And I think a lot of lawyers that are embracing the technology do too.
Yeah. And I love the point you bring, because it's so true. I remember as a young litigator, and I represented a lot of parties in construction arbitration. Yeah. And I'm a small person, and it was hard sometimes to project. And now, of course, we're all the same size. That's a very good point.
Yeah, exactly.
No, that's a really important point. I guess, and finally, because this is really sort of a touchy subject, because hiring some kind of a technologist or technical assistant, of course, does add a bit of cost to the arbitration for the parties. When is the breaking point? What would you recommend to an attorney who's thinking about hiring some sort of technological expert? When do you think a case sort of rises to the level where it's necessary that you really ought to hire somebody?
Well, I'll say this. I would have thought that it would have been very expensive. And maybe when it first started, it did, but it's now its own specialty. And I've heard different names for these kind of people that do it. And the really smart court reporting services are now doing this almost as a loss leader add-on. I've had several arbitrations now where the parties agreed on a court reporter, and that court reporter lined them up with a technical bailiff or whatever you want to call them. And it was really quite reasonably priced, in the low hundreds of dollars for a couple of day arbitration. So the cost, I don't think, is as much an impediment anymore. And the tip I would say is, if you're finding yourself as the lawyer distracted in your advocacy by the technology, then get some help.
Great point. 100%. No, I think that's really good advice. Well, listen, I promised I wouldn't take up too much of your time, so I'll have. But this has been fantastic. It was lovely talking with you, Karl. Thank you so much.
Thank you, Amy, very much. Bye-bye.